Bennett.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20. Now 21 cases. Just since 2020, possession 1 to 4, unauthorized use, possession 4 to 200, 21, evading arrest, felony theft, felony assault, felony possession of a controlled substance, possession of a controlled substance, possession of a controlled substance, now 24, possession of a controlled substance, possession of a controlled substance, assault, unauthorized absence from correctional facility, PCS, now 25, just from 25, PCS, unauthorized use, and now you have an evading arrest.
Those guys.
Stop.
Whoa, 25 charges just for possession.
Okay, pause. 25 charges? That's not a second chance, more like a full-on sequel. And now he's evading again? Question for you. How many red flags does it take before the justice system finally stops handing out white flags?
And unauthorized use? That's not a criminal record, that's a rap sheet novella. And now? Another evading arrest? Let's be real, how many second chances can someone run from before the system stops chasing? Audience, what do you think? At what point should past behavior determine future consequences?
I didn't ask you to say anything. You missed court, and now you're here. If you ever miss court again, and let me tell you something, Mr. Price, I'm going to do everything in my power to protect my city at all costs. If I find that you are one iota of danger to it, it's really not going to go well for you. Do you understand me? You're now charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Thank you, Judge. On April 14th, 2025, in Harris County, Texas, an officer was patrolling the area of 999 Pasadena Boulevard, the Macro Plaza Mall. The mall is closed during the early morning hours when this incident occurred, and no maintenance or cleaning personnel were on scene. 999 Pasadena Boulevard is near 1202 Pasadena Boulevard, which the officer knows from training and experience to be a high drug area. The officer observed the defendant standing near a mechanical box on the side of the main building of 999 Pasadena Boulevard. The defendant looked at the officer, who was in a marked patrol unit, and began walking toward his bicycle, which was laying on the ground nearby.
Let's talk law. Just because someone runs doesn't mean they're guilty. The judge found no probable cause here, which is huge. Probable cause isn't just about gut feeling. It's about facts. Suspicion alone doesn't cut it in court.
Due to the above circumstances, as well as defendant's suspicious behavior, the officer initiated a subject stop on the defendant due to reasonable suspicion. The officer activated emergency traffic lights and began sounding the siren of a marked patrol unit. The defendant continued to ride his...
Okay, let's pause. He evaded for 736 feet on a bike and then on foot. And the judge drops, I find no probable cause. That's not just legal drama, that's a courtroom mic drop. You can practically hear the tension evaporate. Legal insight. Probable cause isn't just about being suspicious, it has to be backed by facts. Even if a suspect runs, the why still matters.
The bicycle away from the officer, standing up on the seat of his bicycle to accelerate faster. The defendant eventually fell off the bicycle and continued to evade on foot until he fell in the roadway of the 900 block of Pasadena Boulevard. The defendant evaded the officer for approximately 736 feet.
The hell is he doing wrong? Riding a bicycle while white? He's not doing anything.
That line hits hard. Life is too short to end up in a 6x9. It's courtroom wisdom wrapped in a reality check. For everyone watching, what would you say to someone spiraling into this path? Let us know in the comments.
Just the presumptive police. No. Mr. Price, I'm going to find that there's no probable cause in your case today. We have enough death, dismemberment, and danger in our town as it is. Don't create any more. You know, be a good person. It's not hard. Get a job, do something with your life before something, or you end up with a 25-year sentence. You know, it's lickety split. Something happens. Life is too short to end up in a 6x9 with a 25-year sentence. You know what I mean? Really. Please take a seat. Ma'am, you're charged with assault, causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 1 day that you've done. You need to understand that you're making a lifetime decision today where this assault is going on your record and it will be there for the rest of your life. You can never take it off. From now on, you'll be facing a minimum of 90 days in jail for any new cases that you pick up. Do you understand?
I'm facing 90 days.
If you pick up any more cases,
Oh, yes, sir.
facing a minimum of 90 days in jail.
Yes, sir.
You're giving up the right to is this on doctor?
It's on diet.
Giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization, give up the right to appeal. Once you accept this agreement, you can never change this or undo this. Do you understand?
I do understand that.
This isn't like Target where you don't like it. Oh man, this is hurting. You can return it. No. Once you plead guilty, it stays with you forever. You never change it. If you're not guilty, don't plead guilty. It's just that simple, really. Don't, because you'll always live with regret.
Sir, I was assaulted first.
I can talk to you about that case. Right? You're telling me that it's self-defense?
A child a day?
Yeah. What do I do?
She's gonna show up.
She won't.
Excuse me. I'm happy to give you more time to discuss it. Just, it's probably not best here. I live stream, so.
We go for tomorrow, Your Honor.
Sure.
Okay, thank you, sir.
Morning, Mr. Tolentino.
Good morning.
So you're charged with illuminating an aircraft with a laser pointer. You're facing up to a year in jail and or a $4,000 fine. The agreement that you have worked out is a 6-month deferred adjudication. This is a very serious agreement that you're entering into now. This is a type of probation that if you complete successfully, you do not end up with a conviction on your record, but you cannot tell people it was dismissed. It doesn't get dismissed. You do a probation, complete it successfully if you do, and you don't end up with a conviction. Do you understand the difference? You give up nearly every right known to man by entering into this agreement, telling us that you can complete this. And if you don't, you're facing an entire year in jail. Do you understand? You're giving up a lot of rights. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you are stuck with this until you complete it successfully or it gets revoked. If you do something to violate this agreement, like you pick up a new case, you don't do your class on time, you don't do your community service, I'm going to issue a warrant for your arrest, and we're going to have a hearing to see if you violated. If you do, you're looking an entire year. Do you understand? You still want to do this?
Yes, sir.
How do you plead to the illuminating an aircraft with a laser pointer improperly? Guilty or not guilty?
Guilty.
Now this is what deferred adjudication looks like done right. It's basically a legal probation challenge. Finish early, get out early. But mess it up, full sentence. Think of it like legal Jenga 1 wrong move and it all collapses.
I'm not going to find you guilty. I'm going to withhold it for 6 months. You will do an effective decision-making class, thinking for a change. No drugs, alcohol, 25 hours of community service. Did you graduate from high school? Okay, what are you doing now?
Electrical. I do electrical.
Huh?
Yeah.
Okay. I want you to maintain full-time employment while you're under probation as well. I'll make you a deal. If you do well,
This is where things get murky. Buying stolen goods online without knowing they're stolen is one thing, but once intent is proven, it flips the switch. So here's the real question. Would you recognize a deal that's too good to be legal?
You get everything done quick, I'll take you off in half the time. Meaning get your classes done, be nice to everybody. And if you do that, we can take you off in half the time as a reward. But if you mess up, it's not going to go well. Do you understand?
So,
All right, bud. Good luck to you, sir. Thank you, Judge. Thanks, John. Okay. Mr. Aguilar, you're charged with failure to stop and give information striking a highway fixture. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You're also charged with theft, a Class A misdemeanor where you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. Law enforcement officer spoke with the complaining
Buying tailgates for $75 and flipping them for $400? Sounds like hustle until the law knocks. The big question, did he know it was stolen? That's where intent flips this from Craigslist commerce to class of theft. You tell us if someone sells suspiciously cheap stolen goods, are they guilty or just gullible? Drop your thoughts in the comments.
witness who stated that on April 2nd, 2025, he parked his truck in his company's parking lot, locked the truck, and when he returned the next day, his tailgate was missing. An employee of the complaining witness searched Facebook Marketplace and found a tailgate that matched the complaining witness's stolen tailgate and had recently been published. The law enforcement officer executed a sting operation to purchase the tailgate from the defendant, the seller, on Facebook Marketplace. He paid the defendant $140 for the tailgate. The defendant was subsequently arrested. The complaining witness stated the price to replace the tailgate was $1,117.65. The defendant stated he buys the tailgates from a friend for $75 and resells them for typically $300 to $400.
We have him taking the actual tailgate, right?
Yes, Your Honor, that's what it says. Well, it has him as the seller of the tailgate.
yeah, I didn't take the Your Honor.
Stop. Don't say anything. You have the right to remain silent. Exercise that right.
Yes, Your Honor, it has him as the seller and that it was recently published 2 hours ago on Facebook Marketplace. But those are the facts as far as the dim summary goes.
It says here that this defendant did then and there unlawfully appropriate by acquiring or otherwise exercising control over property, namely a tailgate owned by Jonathan Smith. Did he take the actual tailgate?
Your Honor, there are no facts alleged in the DIMS that he knowingly took the actual tailgate. However, the tailgate was in his possession and under his control.
Sure.
And he was the seller on Facebook Marketplace. There's no information in the DIMS, though, that represents that he was the actual individual that stole the tailgate. In fact, when the officers interview him, he says that a friend, he buys the tailgates from a friend and then resells them on Facebook Marketplace.
Are we to assume that he knows that they're stolen? You know, he's charged with theft, right?
Yes, sir.
It's a specific intent crime. So if he's selling stolen property, somehow there has to be evidence that he knows that it's stolen. How do we know that he knows it's stolen? We don't operate on hunches.
Your Honor, there is also an allegation, or it's alleged in the DIMS that the defendant told the law enforcement officer that he was aware the tailgate was stolen.
Well, there you go. Okay.
Thank you. It's my fault.
Mr. Aguilar, I'm going to find if there's sufficient probable cause to go forward in the theft case. What about the failure to stop and give information?
Failure to stop and give
Let's see. We need to do probable cause on that one as well, please.
Good, Your Honor.
Yep.
Law enforcement officer was following up on this case in the original report. The defendant's vehicle struck a metal gate at an apartment complex. A witness looked out her window and saw the suspect vehicle and photographed the driver and passenger as they exited the vehicle. Law enforcement officers ran the plates and had the vehicle and owner information. The law enforcement officer later observed the defendant's vehicle in front of the residence. The vehicle had significant damage to the hood. The law enforcement officer made contact with the driver, the defendant. The defendant was ID'd to be the vehicle owner. The defendant
Yep, that's the judge's way of saying, test me, and you'll be bald and behind bars. This isn't just anger, it's policy. Courtrooms run on accountability, and some judges don't sugarcoat consequences.
stated he loaned his vehicle to an acquaintance he only knows through Instagram. The defendant showed the law enforcement officer the man's Instagram named Go Get a Veil. The defendant claimed that this man needed to borrow the car to pick up a girl. The defendant stated he would obtain the man's real name and provide it to the law enforcement officer by the end of the day. The law enforcement officer was not contacted by the defendant again. The law enforcement officer took a still shot on his body-worn camera of the defendant during the conversation. The law enforcement officer later compared the photos and saw the defendant was the same as the photo from the reportee. The law enforcement officer attempted to contact the defendant and could not. The apartment complex's estimated damages are $2,000.
Got it. Mr. Aguilar, I'm going to find that there's sufficient probable cause to go forward on both of your cases. Can you tell me if he has a license to drive, please? Texas driver license.
John, can you check that on Aguilar?
Don't. I know that you are itching to say stuff. Don't. You have the right to remain silent. Exercise. I've got a bunch of DAs here. Whatever you say, they're going to use it against you. So just now's not the time to fight your case. You will have the opportunity to fight it. Just now's not the time. I want you to understand, Mr. Aguilar, I will do everything in my power to protect my city at all costs, including property. And if I find that you're a danger to my city, I'm going to lock you up and I'm going to make your bond so high, you'll have hair falling out.
Yes,
Do
Your
you
Honor.
understand?
Yes, Your Honor.
Your Honor.
Tell me what time of night was, do we know the theft of the tailgate? Was it in the middle of the night?
So it was reported around 5 p.m. That's the only information we have, Your Honor.
Okay. I'm ordering you as a condition of your bond not to pick up any new cases, not to have any contact with the complaining witness in the theft case, not to go within 200 feet of where they live or where they work. Do not pick up any new cases. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name, and that is also a bond condition. If I find that you're driving without car insurance, likewise, you will go to jail. That's it. If I end up revoking your bonds for one thing or the other, they're probably going to end up around 10, maybe 15,000. And if you don't have anyone to pony up that kind of money, you will be stuck like Chuck in there until this case is over. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer?
Yes, sir.
Okay. We are going to give you time to hire a lawyer. So I will have you go to Victoria, sign a reset. After that, I'm going to have you take a seat in the jury box while we get your bond conditions. We'll have you sign it. After that, you'll be free to go. Just don't be a danger to my city. Do you understand me?
I understand.
Come on. Good morning, Mr. Chimeo.
Good morning.
Good morning.
Charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 27 days in jail with credit for the 9 days that you have done. You need to understand that this charge from now on will go on your record. It will be there for the rest of your life. From now on, you're facing a minimum of 90 days for any new cases, at least with DWIs that you pick up. You ever get pulled over again, officers will see this DWI and they roll up to your window and they smell alcohol, or if they smell dope, it's probably not going to go well for you. So I would never get into a car and drive if you've even had a sip of alcohol. Do you understand?
Yes.
You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal, meaning once you plead guilty, this goes on your record and it will be there for the rest of your life. Is this what you want to do?
That's it.
Yes.
Is it true or untrue that you had a .15 or above breath test?
¿Verdad o no verdad?
Verdad.
True.
I find that it's true. I'm now going to sentence you to 27 days, give you credit for the 9 days that you've done. I'm going to suspend your license for 90 days. Do not drive until you get a license, and good luck to you, sir. Thanks.
Judge, I was appointed to this case about 8 days ago, Judge, and I don't believe his energy status has changed since then. Can we have the court waive the DPS fee? Thank you, Judge.
Okay.
Ya,
Wait.
con la base.